Warm welcome to all of you at this event organized as a lecture by Professor Frederic. I'd like to recognize the presence of the dais, Justice Sri Krishna, Justice Singhi, and Mr. Sikri as well on this occasion. As we had sent out the invitation, and if you recall, Fred had served on the French Supreme Court for about nearly 8 years, having been a competition expert as an economist. The first time an effort was made by the Supreme Court of France to have an economist on board. The only other instance that I know of in a high court, New Zealand has an economist on the bench. And similar to that, the Competition Tribunal of South Africa for a long time had an economist as the chair. So the fact is that competition law is an economic law. It requires an understanding about both law and economics, as we were discussing today in a conference organized by Anurag Goel. He's also here. And under the banner of I Am Kanpur, this issue had cropped up again and again. And the need which arises is how do we train our judiciary in order to understand economics, especially now that we have a Commercial Courts Bill and Commercial Courts Act, and that there would be special courts set up to resolve particularly disputes relating to Contract Act and so on and so forth. It would be important for a better understanding in terms of how economics plays a big role in commercial disputes. Fred has gained a very good experience, which he's going to share with us this evening. And very happy that he's here. He's chairman of the OECD Committee on Competition, as also, among many other things, he's also chairman of our advisory board since long, and has been a mentor and a guide to me.
It's a pleasure to catch up with Professor Jenny after about 12 years. 12 years ago, I met him in the same premises. The first question, I was introduced to him as a judge of the Supreme Court, whatever the equivalent they call it. What is it? Something. What do you call it?
Cour de cassation.
Cassation, cause of cassation, the Supreme Court in France. So, and I assumed that he was a lawyer, and then during the conversation it turned out that he was not a lawyer at all. I thought, how on earth did they make you a judge of the Supreme Court? Then he explained to me that his expertise was in the competition law, and that as an economist, he was recognized as an authority on the subject, and maybe the Supreme Court needed his assistance. He was taken. He told me that he had 8 years tenure and he has recently retired. Now, Mr. Mehta just now mentioned that there are very few courts where economists are allowed to sit on the bench. I think I personally think, I don't know, it's my personal view, that in the Supreme Court of India too, this should be followed. I'm happy that this kind of a seminar is being organized where Professor Jenny is going to address us. He is an expert on the subject and we are all willing to listen and learn from him. I present you Professor Jenny.
For having invited me. It's a bit intimidating to talk about your own experience, so I'll try to hide part of it behind a more general discussion of law and economics, particularly in the competition field. I hesitated on what title to give to this little lecture, whether it was a singular journey or lonely journey, and I think there was a bit of both, but I chose lonely for reasons which possibly will become clear later on. I did just a little bit of background and a bit of historical facts, though, and I will talk both about what has been my experience in France before I came to the court, and the kind of education I got, and why it was that I was personally interested in the interface between law and economics. And second, what led, in fact, to my being appointed to the court. In other words, what was the thinking on the other side. So in terms of education, we've had great economists in France. The last one died early in the 19th century, but they are still quite important. And as a matter of fact, during most of the second part of the 19th century and the first part of the 20th century, économie politique, political economy, was a sub-specialty of law schools, and it was taught in law schools. And then somewhere around the early 50s, the political economy was transformed. It was really, what happened was the mathematicians took it over, to be honest, and it was not taught in law schools anymore. It was taught in economic school, but it became very highly mathematics, at least in its presentation, and mostly interested in macroeconomic issues, because this is where the economies could make a contribution to very easily. At the time, there was not much competition. Microeconomics was not so popular. So I went through my education in economics in France without taking any law course, because by that time the law schools and the economic schools were quite separate. Then I went to the US, and there I realized, probably because I deepened my understanding of microeconomics and markets, the extent to which, as was said earlier in the day in another conference, markets mean contracts, contracts means legal framework, and the performances of economic system are very dependent on the legal system which underpins the economy. And I must say that this experience has been, I mean, first of all, I realized this intellectually in American universities, but since then I've traveled a great deal throughout the world, and it's so obvious for people for someone who has traveled quite a bit, that the differences in performances of economies are partly, not entirely, but based on the differences in the legal system and the robustness of legal systems to support a market economy. And by this I don't mean only competition law, contract law, bankruptcy law, commercial law in general, intellectual property or property law in general. All those have to be included. So I've always been interested by the interface. And when I came back to France, I became an antitrust enforcer in the French competition office. I participated in the creation of this office, and then I found a job for myself in the office for many years. But I was always personally very sensitive to the idea that the ones who were going to interpret the competition law were going to be the judges who heard on appeal of our decisions, and very mindful to try to understand where they were coming from and to try to make them understand where we were coming from. So there was reference this morning to the fact that sometimes competition authorities only look at the economic side and are not so mindful of the legal constraints that should go with their trade. I must say that right from the beginning I was much more interested in the interface between the law and economics, and making sure that there would be a degree of understanding of what we were doing. Possibly because competition was so new to France that nobody understood anything about it, and so I needed to explain that. I was indeed, for nearly a decade, considered to be having been too influenced by my US studies and bringing the American ideology to the French culture, which was not without its problem. Now, on the other side, on the side of the courts and the judicial system, in the 1980s and 90s, early 90s, there was a realization among a small number of very important judges that economics was becoming quite prominent in the cases that the judiciary was hearing. Now, first of all, a little background. In France, we have two Supreme Courts, an administrative Supreme Court called the Conseil d'État, and a civil and criminal Supreme Court, which is the Cour de Cassation, which is where I was. I'll put aside the administrative law for a while, and I will focus on the civil and criminal law. And the reason for this is, of course, that the 1990s were a period of deregulation, privatization, opening up of trade, and the end result was that a number of matters that used to be dealt with by ministries were now sent to the courts. And those judges said, we have many more cases, not necessarily in competition, but also in contract law or in public procurement or in many more issues that come to us that require some understanding of what the economic underpinning of the cases are all about. How could we get this? Because we want to be not only legally correct, but we want to be economically relevant. And we don't have a clear sense of what is relevant because we're lacking an education in economics. One of the very important judges that guy was the Chief Justice of the Cour de Cassation, who himself had studied competition law and become very interested in competition law, and was, in a sense, an agent for change. He looked around to see whether he knew of an economist, and I was the only one that he knew, so he came to me and suggested that it would be interesting, would I be interested in joining the court, because he wanted to see what interface or what discussion could get going between an economist, sitting not as an economist but as a judge, and the other judges. At the time, I couldn't take up this offer because I was doing things at the WTO, so I said, I'm sorry, I've got a mandate at the WTO, I first have to finish that. This Supreme Court judge retired, but his closest colleague became Supreme Court judge and pursued the same idea and came back to me after I'd finished my time at the WTO and said, would you be interested in coming? And said, well, how can economists become a judge? Said, well, we have a provision in France that, so a little background, how does one become a judge? All the judges in the civil law and in criminal law are professional judges. So you go to law school. At the end of law school, you decide whether you want to become a lawyer or whether you want to become a judge. If you want to become a judge, you go to magistrate school. There's a competitive exam to get in. Then there are 3 years of school. Then after that, you become a professional judge and you stay a judge all your life. And slowly but surely, you move from one position to the next, and some of them get to the Supreme Court. So the Chief Justice of the Supreme Court said, well, we also have the possibility to appoint lawyers. And I mean, there are very few, there's but one a year was appointed, so this is rather exceptional. But the law doesn't actually say that you have to be a lawyer to use this. And we would like to try to use this provision to suggest to the Judiciary Council. The Judiciary Council is the council that made the appointment together with the president at the time, and now it's only the Judiciary Council, to push your candidacy if you're willing to try this. I thought this was a fantastic opportunity, that I was going to be able to learn something entirely new, something which I had touched upon, but fairly superficially and in a fairly narrow way. And I decided that I wanted to be a candidate for this. So it's a long process, takes a year of. It's not like in the U.S. where you have those hearings in the Senate and Parliament, but you do have to appear in front of a number of commission of judges. And I mean, just a tiny memory of the very last meeting, which was in front of the full Judiciary Committee, and the Judiciary Committee was pretty much like you. I mean, it was, and this was the final thing that was either I was going to make it or not. And what was really interesting during this was that the judges did not know what to ask me because they'd never seen an economist before, and they knew that I didn't know any law. So, I mean, they asked me to, tell them what I had done, and as I went on, I mean, they seemed more and more perplexed until one of them said, "But you seem to have a really interesting life. Why the hell do you want to come to the Supreme Court?" And I said, because I think it is extremely interesting. But then they had a lot of difficulty because you're supposed to have an exchange. So finally, one of the judges of the Judiciary Council asked me, what's the most profitable crime in France these days? You're an economist, so you should know something about the profits that criminals make. So what's the most profitable? Without thinking, I answered that I thought it was the drug business. And then I started explaining from the point of view of an economist why it was that the drug business was so profitable, which was basically because the strategy that we have is a strategy of going after the traffickers or the dealers. But of course, the more you restrict the supply, the higher is the price of drugs for people who are dependent, and therefore the higher are the profits. So you've got more risk, but you also have higher profits. So it's a self-defeating strategy. And then I heard myself, I said, you're explaining to the Judiciary Council, who's considering whether you should go to the Supreme Court, that one should legalize drugs? I mean, is that what you're doing? And nevertheless, I finished. I left and said, this is it. I blew my chance. Not at all. There was no other question after that one. I mean, that was it. But somehow the Judiciary Council accepted my candidacy. So I was going to be the first economist being a judge on the Supreme Court. And let me go back to the challenge that you all know. But let me go back to something which I found out. I'm using this, and by the way, this seems to be very sexist, but this has been produced by a female economist, rather well known in the US. But I'm using this because I think that behind this there is something which is very true. Economists see the world in the following way. They have a model of how the world should be, an ideal model which they like. Okay. Then they turn to reality, and they see that reality is not like the model, so then they try to make reality more like the model. I very rapidly learned from the judges that they look at reality first, and then they look at legal principle, they see whether the legal principle apply to the reality, and if so. But the starting point is very different, because when you start from a model, of course, you are going to have all kinds of simplifying hypotheses, which are going to be seen as highly questionable by judges. So this difference in approach, I think, is very important. So the judges were, some part of the judiciary was trying to improve the economic understanding of civil and criminal courts, but mostly of civil courts. Now, this is an issue which exists in many countries, and of course this is an issue which in the era of competition is particularly important, both because the underpinning of competition law is in fact economics and market economics, but also because over the last 15 or 20 years a great many countries have acquired a competition law and a competition authority. And the question is that all those new authorities render decision. Most of them are reviewed by courts, and there's always a question about how much will the court understand about the economic. Is the court going to confuse fair competition with anti-competitive practices and all those things? And how could we increase the understanding of courts of economic matters? There are three types of solutions which have been tried in different countries, what I call institutional tools, procedural tools, and methodological tools. Now, the institutional tools, I'm one example of the institutional tools, a rather special one. In many other countries, or in a number of other countries, you have different type of institutional solutions to the problem. Don't want to move to the next one? Yeah. For example, having specialized tribunals, which allows the judges on those tribunals to focus and to invest really in the matter that the economic matter that they're going to deal with, because they are going to have many cases that they're going to review, and therefore it is worth their while. Whereas in countries where it's a generalist court that reviews the decision of competent authorities, it's quite understandable that a normal judge would see very few antitrust cases, and therefore would not have either the time or the inclination to invest massively in this. There are other courts, other countries where on the courts there is either an assessor or an economist who's there only for the factual part of the case, and leaves but he sits with the judges as long as they're looking at the facts of the case to get the right interpretation of the facts of the case, and then, he leaves when there's the decision making. Okay, so there are a number of possible institutional designs which are made, and the Competition Appeal Tribunal, and Mr. Kovacic, who's here, Mr. William, is on the board of the Competition Appeal Tribunal. This is a place where you can have a real understanding or a better understanding. In countries where you cannot have a specialized tribunal, sometimes you concentrate all the appeals on a subset of the judges. Second type of solution are procedural adjustments. Procedural adjustments which are basically aimed at trying to improve the dialogue between either the courts and the experts or the experts of the different parties, to make it more easy for judges to understand what it is that the experts want to say. The typical example of this, of course, is the hot tub technique, which was first tried in Australia. And the intuition there was that, and I've experienced that judges, in many cases, when they don't know what the theory is or the underpinning of the case is, don't know what questions to ask to the experts. So they listen to the experts of the parties, they don't react. Then they decide one way or the other, and then they go back to the expert testimonies to try to see what in the expert testimony supports what they have decided. But this is kind of a reverse engineering. Rather than using the expertise to make the decision, it's using the expertise to justify the decision that you wanted to make in the first place. And part of the reason for this is that they're too shy to ask questions because they don't speak the same language, they don't understand they don't know which question to ask, and they're pretty sure that if they ask a question and get an answer, they won't understand the answer. So the idea is to say, well, there's at least a way to enlighten the courts in those circumstances, which is to have the experts of the parties cross-examine each other. Okay, they know what the weaknesses of the case of the other are. So if they cross-examine each other, I don't have to ask the question. They will find the relevant question. I will see what is left at the end, or at least I will see precisely what are the differences between them and what the case hinges on. And this is a very powerful way to try to make the court understand better what are the underlying economic issues and what are the differences between the experts. By the way, I have many colleagues, economists, who are expert witnesses in all kinds of cases, whether those are civil cases for damages or cases of competition cases. They've always told me, irrespective of where they are, that they don't say the same thing to a court, depending on whether or not they're going to be cross-examined by one of their colleagues. And they are much more outrageous in what they say when they know that they are just in front of the court and the court will possibly react to what they say than when they know that one of their colleagues is going to find out the weaknesses of their. So it also helps to reduce the scope of the tenor of the expert testimonies. The third dimension, or the third type of things that can help, is of course methodological tools. I'm not going to go into this because I assume that you're familiar with it, but it's the use of things like the Doebert methodology, which comes out of the US, which is basically a way to try to assess for the judge what is the relevance and what is the reliability of the methodology of the experts. And you can transform this, this seems to be very abstract, but you can transform this into very precise questions. First of all, the revised Rule 702 of the US gives a number of pointers. Is the testimony based on sufficient data and facts? Is the testimony the product of reliable principles of methods? Has the witness applied the principles and methods reliably to the facts of the case? And if you go down into more detail, you can find a great number of questions that any judge, even if he does not understand anything about the issue, can ask an expert, and which is going to help him form a judgment about the value of the expert testimony. Where did you get your data? Did your client give you your data, or did you get them independently? What the theory that you used. I mean, where was it published? Was it published in a review which is peer-reviewed, or was it just made up for the case, and so on and so forth. So there are ways to help judges ask questions which are very relevant. There's a last possibility which I have not touched upon, even though I have spent a great deal of my life trying to promote it, which is to teach the judges. I mean, to have seminars or conferences where there is some exchange between the economic experts and the judges. I must say that, at least in the context of France, I had limited success until the day I became a judge. That day, everybody came to my classes, judges who would not have come before that because I was not one of them. And there was an element of comfort from knowing that I was one of the judges, and therefore I was less threatening. I mean, I was not promoting some interest, hidden interest, and therefore the fear that the judges might have had about the fact that they would be instrumentalized by this teaching disappeared very fast. Okay. Now, something happened when I got to the court. All of a sudden, I started speaking in a completely different way that I used to speak. Some expressions that were absolutely part of my current vocabulary disappeared entirely, and some other came up. And behind those were, of course, differences of approach. The goals of competition law, for example. Okay, so we talk about the goals. I mean, this afternoon and this morning we spent quite a bit of time trying to figure out what the real goal is. It consumer surplus? Is it total surplus? And so on and so forth. The judicial perspective is, I don't know what you're talking about. What I know is what the law says or doesn't say. And I'm going to take a literal interpretation. I mean, this is of course, I'm talking about French civil law judges, but I'm going to take a literal interpretation of what the law said. And when you talk to me about what is the goal, what should it achieve, it's a foreign language to me. I don't understand that question. Relevant facts. The economists say, oh, okay, so we've got to find the relevant facts. We'll start with the relevant market, and then we will separate out from the facts the thing that, from the economic point of view, have a meaning to try to decide whether or not the practice or the transaction was anti-competitive. The judges had a very difficult time understanding the concept of relevant facts. There were facts, and that's it. I mean, the facts were facts, and the rest was law, but there was no subdivision within the facts of the relevant facts, and therefore, sometimes they would spend a lot of time discussing things which were not really germane to the discussion, because they did not have the apparatus that the economists have. The first time I talked about theory of harm, I mean, there was silence in the room. Nobody knew what I was talking about. A theory of harm, what do you mean? I said, you mean a scenario with a hypothesis and conclusions saying that if competition had prevailed, this is what we would have observed. They did not understand what that was, and they did feel that it was rather ambitious on the part of economists to have a theory of harm, to be able to have hypotheses and believe that those hypotheses were reflecting reality, and they never wanted to go into theory of harm, but on whether or not the general legal principle, whether there were precedents that show that those legal principles could apply to the situation rather than developing a theory of harm. I will give an example later on. Indirect evidence, direct evidence. Now, of course, economics is indirect evidence. I mean, it's a simplification to try to interpret the reality, so it's not... I had a lot of difficulty with some of the judges who clearly preferred direct evidence, testimony, statements, whatever, pieces of paper. And we had long discussions about whether or not they had ever seen gravity. I said, in your normal reasoning, you make assumptions. You have never seen gravity. The only thing that you've seen is a consequence of gravity, is that if you, lean over the window, you fall. Okay. So you are convinced that gravity exists because of its consequence. Well, economists approach problems a bit like this. Okay, so there's not much difference between the common sense interpretation of the world and the indirect evidence that we see in economics. Now, correlation causality, particularly in damage cases, I mean, this is hugely important because the judge needs a relationship, needs a harm, a violation, and a direct causal relationship between the harm and the violation and the damage. And the economist comes with a model that says, well, you know, there was a cartel and the price was higher than it would have been, and after the cartel it was lower, and that's it. And the judge says, yeah, but there may be many other reasons for which the price was higher. He's never convinced that the correlation or the econometrics stands up to the very high level of causality that he has in mind, which is partly an illusion because I'm not sure that one could argue that scientifically the level of causality is higher. Type 1 and type 2 errors is something also that economists always talk about. I mean, they start from the premise that the courts may be wrong, okay, which is not something that the courts start from. And they say, well, you know, you may be wrong because you are too harsh and because you are preventing some behaviors which are not anti-competitive, or you can, this would be a type 1 error, or a type 2 error would be the fact that you would miss an antitrust violation or a transaction which is anti-competitive. And the economists derive from this what the rule should be, the rule of law should be, by trying to minimize the cost of type 1 and type 2 errors. I've never seen a judge who thought in those terms. Thought in the terms that he was making a mistake and he was trying to minimize the mistake, at least not in French. And I must say that they had also, but this is more the civil judges in I don't know, I would say in Europe, with the concept of standard of proof. The first time I said, you know, I had a case and said, what standard of proof do you need? Do you apply? And there was silence, and I said, you know, the manifest error of appreciation, or default in reasoning, or beyond a reasonable doubt. All this was like Chinese to them. They said, we want to be convinced, which did not really answer my question, but there was a very different approach there. Economists love to talk about sanctions, which should be higher to deter anti-competitive practices in the future. Judges love to talk about whether or not the sanction is proportionate to now, between deterrence and proportionality, there's an obvious tension between the two, which means that in many cases and in many countries, the courts are going to overturn the sanctions because they think that they're completely disproportionate and because they don't have a concept of the fact that the way they apply the law has the purpose of deterring future. They just apply the law as it is. Optimality and predictability. I will tell you a story in a minute about this. The economists look at whether competition law is applied in the right way. In the right way in the sense that it promotes efficiency, it promotes optimality, it promotes better allocation of resources. If it turns out that economic thinking has evolved, and a good example of this would be two-sided markets, for example. When European jurisdictions started being interested in banking in cards, they didn't really know what the two-sided market was, and the theory of two-sided market was hardly born. In fact, it was developed by Tirole and others following those cases. This is a case where the judicial approach preceded the theory. But what's happened? Well, the economists have insisted that now we understand what they are, so therefore we've got to change some of those horrible decisions that were made originally because they don't make any sense, because we didn't realize that they were two-sided markets, so we looked at one side and then we looked at the other side, and we never looked at the interdependence between the two sides, and that ruined the reasoning. So the economist is very keen on making sure that the reasoning is the most appropriate reasoning given the state of the art, which is the economic theory. And if you have to change your opinion, you change your opinion because it's a good thing to have a better application of competition law. The judges are not at all interested in optimality, but they are highly interested in predictability. They want the law to be predictable. Okay? And a law which is predictable is a law the interpretation of which doesn't change every other day. Okay. And that turned out, so now I'm going to talk about the very first case I had, which was not a competition case, because, oh, by the way, I should have said, in the French Supreme Court, you have chambers. Those chambers are, there are 6 chambers, so I was in the commercial, economic, and financial chamber. So we had intellectual property, we had some tax law, we had competition, and a lot of contract law. So I worked on all those issues. So the first one, the very first case I got, I had been in the court less than 2 weeks, and I was given this case, was the case of an importer who had imported some textile from a territory which had a special status. It was not Mauritius, but it would be like Mauritius with respect to European law. And to resell those textiles products. And the custom authorities had hit him with an import tax when he was claiming that given the special status of this territory, there should not have been a tax. Custom duty. So he went to administrative court and won eventually, and this custom duty was repealed because he was not. So he then went to civil court and said, all those years I've paid this tax, so I want to be compensated for my damage. And the case worked its way through the appeals court, and the appellate level, the big question was, did you pass on to your customers the increase in the tax? And the answer was absolutely yes. And the court said, well, absolutely go away. We have non bis in idem, which is the same as no double jeopardy. You have passed on the increase in the tax. You have suffered no damage. Go away. And the case comes to me. And I look at the jurisprudence, and there's this thick jurisprudence. I mean, this is a 31st case of that type. And they all go in the same direction. And they all say, if the damage has been passed on, that's it. There's no claim for damages. I'm very embarrassed because I disagree. But I disagree with the jurisprudence, which is extremely well established. And I disagree because I think, when you increase your price, you sell less. So at least you lose the profit on this little triangle that economists love of, how much more you would have sold if you had not had to pass on the tax. Okay. So, nevertheless, I said, well, being an economist, I have to say that. So I try to explain to my colleagues that I know very well the jurisprudence. I quote every other judgment to make sure that they know that I know what the law is. And I said, having said that, the jurisprudence is wrong because there is a residual damage. And there is a residual damage because when you increase your price, you sell less, and therefore you lose some profit margin. So the first round of discussion, and remember I was very intimidated, but at the same time I felt that I had to make the case, was where did you get the idea that when one increased the price, one sells less? And they took every possible example, gold, art, diamonds, things that were bought because the price was increasing. I said, yes, the price is increasing, but it's not because the price is high. It's because you hope that tomorrow it will be high. It's a different issue. Okay. So, but in any case, so it went on and on. But it struck them as being a theory, not substantiated by anything else, but by hypotheses which were questionable. Okay. So eventually they decided that possibly, as I explained to them, I said, if you could increase the price and increase the quantity you sell, probably we wouldn't be sitting here in this room. I mean, we'd be selling whatever, increasing the price, selling more and more of it, becoming richer and richer. Okay, so I don't know whether that convinced them or not. Okay, but the second round of discussion was, let's assume that Jenny is right, and indeed, when you increase your price, you sell less. Is this the right case to change all jurisprudence? And I was quite interested in this phase of the discussion because this is a question that would not have come to my mind. Because coming from an economic background, you had faulty reasoning, you change it to have a more optimal reasoning. But that's where I really understood that they said, we are perfectly willing in some cases to have the wrong reasoning in order to protect the legal predictability of the law, in order not to change the law or the interpretation of the law all the time. Okay. So is this the perfect case? Best case? said, this is as simple a case as you can get. It's very pure. There's nothing else but this question. So in my mind, it's a very good case. Okay. And since the jurisprudence is quite old, I mean, it's now probably is the time to change it. The third round of discussion was, okay, let's assume that Jenny is right, and let's assume that this is the right case. Should we send it back to an appellate court? Because if we do that, what's going to happen at the appellate level? The appeals court is going to have two sets of economists, the economists for the custom authority, the economists for the importers. They are going to come with fancy description of how much would have been sold if the price had been different. The appeals court is not going to be able to understand who is right and who is wrong. It's going to take forever. And maybe as in terms of being expeditious, we should affirm the case, even if it's the right case, because it's going to be too complicated for the courts to understand the economic evidence. Finally, I won, which was made me feel relatively good. The case was sent back to an appellate court. 8 years later, when I left the Supreme Court, I think the case was still in an appellate court. So, now, how convincing is that? Well, this is extremely convincing, except if you add a time trend. Because if you add a time trend, then you don't see any difference between the time of the cartel and the time and the period after the cartel. So there, the specification of the econometrics makes all the difference in the world to tell you that there is a real different behavior before and after or not. Okay. So judges have to be aware of that. So that's something that came up in at least one of the cases that we're sitting on. But that means that indeed the judge have to understand some of the economics, and they have to have somebody to explain it to them. So to finish on this, two things. The first one, the first 2 years were hell for me for two reasons. One of them, I didn't know the law, and I knew that I had to learn a lot, particularly because those were the most senior judges. The second thing was that I didn't know how to relate to those judges. We didn't speak the same language. We didn't come from the same background. They knew the law. It was obvious that they knew everything that they had to be known about the law. How was I going to make any kind of impact? Was I just going to sit there and be... And it took me about 2 years to find out that, in fact, they were highly interested in listening to me if they trusted me from the legal point of view. So I would spend an enormous amount of time researching the jurisprudence and looking at the law books, then make a really good legal speech, and then say, okay, now that you know that I understand what the legal issues are, let's talk about something else. Let's talk about some of the consequences of this jurisprudence, other on competition. And it worked, and that's where I used the PowerPoints, and then that worked very well, because they were extremely willing to listen. But it was clear that in their mind, they never mentioned it, but it was clear in their mind that they would only listen to me if they were confident that I really understood what were the possible oppositions between them, or the different trend of jurisprudence that one could apply to. So that's the first part. The second part is, why is it a lonely journey? After the appointments for 8 years non-renewable, because it's not the normal way to recruit judges, so the Parliament wanted to make sure that this is not a parallel way to have all kinds of judges which have not gone through magistrate school, so it's not renewable. After 7 years, the Chief Justice of the Supreme Court calls me in and say, we were a bit suspicious at the beginning. We didn't know how all this was going to work out. But now that we've spent 7 years with you, we kind of like it. We know that you're going to have to leave the court. We would like to have another economist, because we think that it's actually enriching to have this. And in the case law, it has made a difference on a number of issues. Since you know the French economists, would you help us identify another economist? We want a senior economist, because this is the Supreme Court, but more or less in the area which is applied microeconomics where you've been. I went to see I think I know, I've been around long enough, I think I know all the macroeconomists in France that could conceivably have qualified. And so I went to see them, and I said, you know, I've been on the court for 7 years. And immediately they would say, yeah, it's fantastic. I mean, it must have been a great experience. What you did was you really helped the court understand much better and increase the relevance of the jurisprudence and all this, and say, well, good, you know, thank you for saying this. And by the way, I come to see you because my position is going to become available in a year from now, and the court would like to have another economist. And every single one of them said, not me. And when you analyze what they said, not me, there were two things which were very noticeable. One of them is, I don't want to go back to school. You know, I went to school 20 years or 30 years ago. I mean, enough. I'm in my little economic consulting firm, or I'm teaching at the university. I don't want to go back and either learn the law, and because there was no one who had really a double education. The second dimension was purely economic. The opportunity cost for them to become a judge was too high. They were a very successful consultant. So they had families, they had obligations, they had, I don't know, whatever. So the combination of this is that not one of them volunteered to, as a matter of fact, there was one of them who volunteered, who was in Belgium at the time teaching, a Frenchman, but he gave up he decided that it would be too difficult for him to learn the law, and he gave up in the middle of the process. Now, this is why the journey has been lonely, because the problem is that this happened 2.5 years ago. Time goes by, and institutions lose their memory, and they slowly but surely will lose the idea that they had an economist on the court. And I think that this is a missed opportunity, both for the economists, but even more so for the French system of law. My only solace is that the appeals court of Paris decided that on the staff of a competition authority, if you don't understand the legal context in which the courts are going to review your decisions, because either at the procedural level or even sometimes at the substantive level, you're going to make a gross mistake. And I must say I was on the OFD, which was on the board of the OFD, which was the predecessor of the CMA, which had superb economists, probably the highest level team of economists.
What about the UK competition authorities?
Yeah, the UK, the OFD, which had the superb and lost a great many cases precisely because the economists did not understand the law. So I think that it's very useful for the judges to get some education in economics, but equally important for economists to get education in law. Thank you very much.